Welcome to Biotech Now. This is Tracy Cooley, and today I am here with Deputy General Counsel of Intellectual Property at Bio, Dr. Sauer.
Thanks for having me.
Thank you for being with us. And today we're talking about patenting and tech transfer at the upcoming Bio International Convention. So to begin with, if I hear about patenting, what's on my mind right now? What are the big issues and challenges facing the industry?
We've lived this for years. There have been, since the last convention, there have been very big changes in the state of intellectual property law, in the United States at least. Right. So since the last convention, the U.S. has passed the biggest patent reform legislation in over 50 years. And while we've been able to see the development of the general contours of that law, over the last couple of years, this law was long in coming, was long negotiated. We now know exactly what the law looks like. We have an understanding of how it may be implemented by the Patent Office and other agencies. So we will have a number of sessions at the International Convention that will focus on the ways biotechnology patent practice may have to be modified going forward to take account of the new law and new regulations that will be implemented by the Patent Office under it. So, for example, the law changes the way companies, including biotech companies, can leverage and treat their trade secrets. There are new provisions in this law. We will have, I believe, an interesting session about trade secrets, which are not much discussed at Bio, at least in the legal track, and so which are now fodder for a new kind of conversation that we haven't had in the past. There are other provisions in the law that create new proceedings in the United States that haven't existed in the past. Administrative proceedings, not court-based proceedings, under which patents can be challenged in the Patent Office to clear up freedom to operate problems between competitors. And these proceedings are new. They're not yet well understood. In Europe, comparable proceedings have existed for a long time, but the American proceedings will be different. They will be implemented in a different way. We fear that they're going to be much more expensive as well. So there's a big interest from BIOS membership and others in the industry in how these proceedings are going to work. We will have sessions talking about those proceedings as well, just to give you examples. But that's only the new law that was passed by Congress, which in many ways makes U.S. patent law a little more similar to the patent laws of our major trading partners and other industrialized countries. So to the extent the law gets closer and becomes more harmonized in the patent field, at the same time we've seen developments in the U.S. courts that make the law seemingly diverge in unexpected ways. So we will have sessions that will talk about some very notorious and very strongly noticed court opinions that we've had recently in the United States. A number of cases that we feel are important for our concept of personalized medicine and how we treat intellectual property in this emerging discipline of biotechnology. Personalized medicine and advanced molecular diagnostics will have their own track at the convention, so there's already a tremendous level of interest being paid to that developing sector of the industry, and a good part of the legal track now will be dedicated to dealing with how we can patent personalized medicine inventions and how that patenting activity that's going on, which is already uncertain enough. People have been trying to figure this out for a while. How those practices may change going forward if certain opinions that the courts have issued will take hold in the field, and how we account for uncertainty that frankly is developing. We haven't had a very orderly development of patent law in this area. So I do expect that especially the patenting sessions that deal with personalized medicine will be packed, maybe even more packed than they have been at past conventions. This has been a subject of great interest for a number of years, and now we've had some developments where people have really said, whoa, what's up with this Prometheus case, for example, that the Supreme Court just decided. That will be, I think, very much debated and discussed at the convention.
Wonderful. It's a complex issues that you're facing, and we look forward to seeing you at the 2012 Bio International Convention, and thank you for joining us today.
Thanks for having me.
And thank you to all of our watchers as well. And for Biotech Now, this is Tracy Cooley.